Well, I guess we can get started. I would like to welcome everyone who is in our Zoom call and also anyone who may have joined us through our YouTube live stream to the annual public meeting of the Maryland State Commission on Criminal Sentencing Policy. My name is Brett Wilson. I'm chairman of the commission, and we have some speakers here tonight, and we'll also be going over some other topics. But before we get to that, I would like the commissioners to have an opportunity to introduce themselves. Now, ordinarily, we would be in a room, and it's very easy to go around a room. It's not very easy to go around a Zoom room. But I will take the opportunity here to first introduce our newest member, Donald Zaremba, who was just recently added to the commission as a representative of the Office of the Public Defender when Mr. Wolf is unavailable to attend. Just a little background, very little background, Mr. Zaremba, but there are some things I thought were certainly worth highlighting. Mr. Zaremba currently holds the position of, Chief for Strategic Operations for the Office of Public Defender, having originally graduated University of Maryland Law School with honors, joining the Office of Public Defender in 1989, and twice being named its outstanding advocate for the entire agency. Mr. Zaremba, I know there's more to your biography than just that, but I just wanted to give at least a brief overview of the road you've taken to come here. But if you would like to, please introduce yourself further at this time.
No, thank you very much for the introduction, and thank you so much for having me.
Well, thank you. And then I hope that you will enjoy your time on the commission. The vice chair of the commission is Judge Shannon Avery. She is here. Judge Avery, would you like to say a word of introduction?
Sure. Good afternoon. I am Judge Avery. I'm a judge in the Circuit Court for Baltimore City. I started my career as a public defender, and I was in the Office of the Public Defender for 7 years in the Appellate Division. And I welcome you, Mr. Zaremba, a welcome addition to our group. Thank you so much for being with us.
Thank you.
I have been on this commission as a judge for approximately six years, and prior to that, and prior to being appointed to the bench, I served as the representative of the Office of the Department of Public Safety and Correctional Services. And so I have had a long history on this commission, and I'm very happy to be here, and I always enjoy the public session that we have an opportunity to hear from people who we don't always hear from. So I welcome all the members of the public today.
Thank you, Judge Avery. And just keeping with the judiciary for a minute, Judge Lewis, I know you're here. Would you mind introducing yourself?
Good evening. My name is Patrice Lewis. I'm a judge of the District Court, District Number 5, Prince George's County. I was trying to look up how long I've been on the commission. This is at least my second term. I represent the District Court, and just recently was reappointed by the governor, coming up on my 30th anniversary as a District Court judge.
Thank you very much.
Thank you.
And probably the longest serving member of the committee, Senator Kelly. I think it's certainly good for you to be here, and please introduce yourself to the public.
Dolores Kelly. I'm a Maryland State Senator and not an attorney. I was on the work group that put this particular commission together and have served since the inception of this commission because I care about these issues. I am a retired college professor and I chair the Senate Finance Committee, but I do a lot of legislation that impacts the work of this committee, and I enjoy working with the colleagues who are here.
Thank you, Senator. And Senator Cassidy, I believe you're here as well.
There, am I unmuted now?
You're good.
Yeah. Hey, Senator Bob Cassidy, I serve on the attorney and I serve on the Judicial Proceedings Committee. Dolores, Senator Kelly and I served on there together for a while, and she's moved on to be a chairman of another committee, and I'm still on the Judicial Proceedings Committee. So good to see you.
Okay, well, welcome. And I heard Delegate Moon checked in. So Delegate, would you please introduce yourself?
Sure. Good evening, everyone. Delegate David Moon. I am an elected member of the Maryland House of Delegates. And I guess I'm here because I serve on the Judiciary Committee and chair the Chamber's Criminal Law Subcommittee. I'm one of the new people, so I think I've been here less than a year. So thanks, everyone.
Well, welcome. Okay, how about staying with elected officials, State's Attorney for Carroll County, Brian DiLeonardo.
Hi, Brian DiLeonardo. As you said, the State's Attorney for Carroll County. I also am president of the Maryland State's Attorneys Association and have served as the representative of that organization since 2015.
Thank you. And looking at my screen, I see Richard Fincy here. Rick, would you please introduce yourself?
Yes, thank you, Judge Wilson. I'm Richard Fincy. I'm a private criminal defense attorney. I am the criminal defense attorney representative appointed by the Maryland Criminal Defense Attorney Association. This is my fourth term, I think, on the commission, and I also serve on the guidelines subcommittee. I'm honored to be a member of the commission and on the guidelines subcommittee, and thank you, Judge Wilson, for giving me the opportunity to introduce myself.
Thank you, Mr. Fincy. And Kathleen Murphy is right below you on my Hollywood squares here. So go ahead, Ms. Murphy.
Thank you, Judge Wilson. Good evening. I'm Kathleen Murphy. I am here as a proxy for Attorney General Brian Frosh.
Welcome to tonight's meeting. Lisa Spicknell, I believe you are next up on my screen here.
Hi, Lisa Spicknell. I am the new Executive Director of Donate Life Maryland, a public member here on the board, and I've been here just about a year now.
Oh. Well, thank you for attending.
Thank you.
It looks like Delegate, also known as Chairman Clippinger, has joined us.
Hi, good evening. I'm Luke Klippinger. I'm the chair of the House Judiciary Committee and very happy to be here tonight on the Sentencing Commission. This is, I think, my second year on the commission. As a member of the House of Delegates, I represent the 46th District, which includes South and Southeast Baltimore City.
Okay. Well, thank you. Dr. Brian Johnson.
Thanks, Judge Wilson. My name is Brian Johnson. I'm a professor of criminology and criminal justice at the University of Maryland, and I think I'm in my second term now on the commission. And my role is as a criminal justice policy expert. So I'm kind of the outside person on the commission, filling that role. So glad to be here. Thanks.
Thank you very much. Miss, and I apologize, I'll probably mispronounce your name, Alethea Miller.
Actually, Judge, that's perfect. Thank you very much. Hi, I'm Alethea Miller, and I am with the Harford County State's Attorney's Office. I am located at the Child Advocacy Center. I'm a forensic interviewer and a victim advocate, and I am also one of the very new members of the board. So hi to everyone this evening.
Okay. Okay, it looks like next one down, Melinda Grenier, are you there somewhere?
Hi, Melinda Grenier here. I am an assistant director with the Frederick County Sheriff's Department. I also serve as president of the Maryland Criminal Justice Association. I'm on the executive board of the Maryland Correctional Administrators Association. I so basically represent local corrections in Maryland, and I am a very new member, about a year, right? Gosh, the time has flown. So definitely this is my first term.
Thank you. And Secretary Rob Green.
Good evening, Judge Wilson. My name is Robert Green. I'm the Secretary of the Department of Public Safety and Correctional Services. My apologies to my colleagues. I am traveling this evening between our facilities, so I do not have a video signal. Good evening to all my fellow commissioners, and look forward to hearing from the public during this meeting. Thank you.
Thank you, Mr. Secretary. Okay, David, did I miss anyone?
No, I think you got everyone.
Okay, Wonderful. Well, again, to members of the public who have joined via YouTube since we began, these are the persons and professionals who make up the Maryland State Commission on Criminal Sentencing Policy. They are all dedicated to this job. It is not just a job that people get appointed to unwillingly. And everyone who serves on this commission has an interest to be here, and certainly an interest in seeing that the purpose of the commission is forwarded as best as we can for all of Maryland. I would like to take a moment, if I can, for a sad moment, simply to put on the public record the loss of a longtime member, Mr. Bill Davis, who had been a representative of the Office of Public Defenders. He unfortunately did pass away this year. In talking with David Soleil about him, he, over the years, always added much to every conversation on policy and on people. There was a wonderful article written about him in a local newspaper, and I think the title is perhaps the most telling statement of who Bill Davis was during his life, as it was called, a titan in the courtroom. We recognize the contributions that he made, certainly to the commission, but more so to the legal community, to the interests of justice, and to all of the many clients that he served so willingly and so voraciously over the years. And I just want to make sure that the minutes reflect that we send our condolences to his family, and that we also praise him in our memory of the outstanding job that he did for the state of Maryland. So if everyone could just recognize Mr. Davis. Thank you very much. Before moving on, I did want to have Dr. David Soleil introduce himself. He is the director of the Maryland of the Commission, and also is going to provide all of our viewers with an overview of what the commission is all about. So Dr. Soleil, please go ahead.
Thank you, Judge Wilson, and well said regarding Bill Davis. Thank you for your comments. That was a nice tribute to Bill. Appreciate that. Well, thank you to everyone who is joining us for the 2020 public comments hearing of the Maryland State Commission on Criminal Sentencing Policy. As we prepared for this meeting, the discussion the commission had was that the history and the purpose and the activities of the commission may not be well known to everyone in the public or anyone else that may be interested in the work of the commission. So we thought it would be a good idea to begin the public hearing today by offering some background information about the sentencing guidelines and about the work of the Sentencing Commission. So to start with just a little brief history of the guidelines and the Sentencing Commission in Maryland. Maryland was one of the first states to initiate a sentencing guideline system. In April of 1979, the Guidelines Advisory Board that was formed by the judiciary approved a system of voluntary sentencing guidelines that were initially piloted in 4 jurisdictions. And then those guidelines were ultimately adopted and approved for statewide use in 1983. The guidelines were in effect for approximately 15 years when the state legislature came in and created a commission to study sentencing policy in the state in general. And ultimately that commission put forward a recommendation to create a permanent and independent sentencing commission starting in 1999. And that created what we are here today, the Maryland State Commission on Criminal Sentencing Policy. We've already gone around and done introductions, so I won't go into this in too much detail. The Sentencing Commission, things that I want to emphasize is the Sentencing Commission is a group of diverse criminal justice practitioners. It is an independent, objective agency comprised of a balanced board of 19 members from all 3 branches of government. And so you met many of those people already that introduced themselves. It is really a cross-section of representatives from all the branches of government and as well as 2 public representatives. So let me get into a little bit about the enabling legislation, that created the Sentencing Commission. That Enabling legislation is provided in Criminal Procedure Articles 6-201 through 6-214. And 6-202 of that article outlines a statement of intent for the Sentencing Commission that included 6 goals. 6-202 states that sentencing should be fair and proportional, and policy should reduce unwarranted disparity. Policy should help inform citizens to understand how long a criminal will be confined. Sentencing policy should help citizens to understand sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentencing. Sentencing guidelines shall be voluntary. The priority for the capacity and use of correctional facilities should be confinement of violent and career offenders. And finally, sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs. The Commission has a few primary responsibilities to help address these 6 goals. The first responsibility is to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished really through the second major responsibility, which is collection and maintenance of an extensive database assembled via sentencing guidelines worksheets. The Commission uses the data to monitor circuit court sentencing practice. The Commission also examines sentencing patterns and reasons for departures within specific offenses and within individual cells of the 3 matrices to consider changes to the guidelines when necessary. And finally, the Commission is responsible for providing training to criminal justice practitioners, including judges, to promote the consistent application of the guidelines and the accurate completion of the sentencing guidelines worksheet. So let's get down to the basics. What are sentencing guidelines? The sentencing guidelines really are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote fair, consistent, and equitable sentencing practice whereby offenders who commit similar offenses and who have similar criminal histories are sentenced alike. The guidelines provide a recommended sentencing guidelines range, and the options can include probation and/or a period of incarceration or corrections options. The sentencing guidelines in Maryland have a few basic principles. First, the sentencing guidelines are voluntary, and we saw that already as laid out in the criminal procedure article. Judges may, at their discretion, depart from the guidelines. The second basic principle is the guidelines are intended to be primarily descriptive. That is, the guidelines should reflect the actual sentences of judges and may be amended when the data indicate the sentences are not consistent with the recommended guidelines range. And third, the guidelines are generally limited to cases that originate in the circuit court. They are not required for district court cases. Jury trial prayers and appeals from the district court are guidelines eligible, but only if a PSI is ordered, which would be a very small percentage of cases. So I'm going to wrap up and just kind of talk about some of the resources that the Commission has. If for those that may not be familiar, the Sentencing Commission website at MSCCSP.org, I think is a very useful resource. It is continually updated throughout the year. For those that may not be familiar, the website provides access to Commission reports, including annual reports, the guidelines e-news that helps to inform practitioners about changes to the guidelines. Also provide access to the Maryland Automated Guidelines System, or MAGS, and the Guidelines Calculator tool. We also have instructional videos for these applications, as well as a general training webinar on calculating the guidelines. And finally, I will note that the Commission has a help desk that we have, someone will answer your call during regular business hours during the week, and we are always available via email. There's one final resource that I want to highlight, and that is recently the Sentencing Commission started producing a series of topical mini reports, which we titled the Sentencing Snapshot. I've illustrated the most recent issue here that was published in October of 2020. This takes a more in-depth look at the sentences for second-degree assaults that are sentenced in Maryland circuit courts. I encourage you to look at these reports on our website if you're interested, and please feel free to offer feedback or let us know if there's specific topics that you are interested in being looked at for future issues of the snapshot. Since its inception, the commission has made it a goal to incorporate feedback from the criminal justice community and from the public in general into its decisions that the commission is making. And so to that end, there are several ways in which the commission solicits and incorporate feedback. First, obviously, this is today we have annually we hold this public comments hearing, and we're lucky to have individuals who have registered to speak and share their feedback at today's hearing. Second, the commission staff meets every 2 years or 2 to 3 years with each administrative judge in each jurisdiction, or sometimes even the entire bench in each jurisdiction, to provide information about sentencing guidelines and to receive feedback from those judges about the work of the commission and the sentencing guidelines. And then finally, in May of 2020, we distributed a survey to circuit court judges, prosecutors, public defense attorneys, and criminal defense attorneys, private criminal defense attorneys, soliciting feedback on the guidelines and the activities of the commission. And we received some incredibly useful responses that will be able to help potentially guide commission on future activities that the commission may want to explore further. Excuse me, and I skipped over the last one. And finally, actually, I said finally twice, but what I wanted to also note is during the trainings of the commission staff, we often receive very useful feedback, or it might be an issue that someone raises about the guidelines that staff hasn't particularly heard before. And so those always are good opportunities for us to get feedback. And often out of those trainings, we're able to bring issues forward for the Sentencing Commission to study. So the commission, I just want to emphasize, the commission recognizes the importance of hosting an annual public comments hearing like we are here this evening. We think it's an important forum for the public to discuss sentencing related issues, and we're very fortunate that we had registered speakers to participate in the hearing tonight. We thank you for taking the time to share your feedback, and we look forward to hearing from you. Judge Wilson, you're on mute, just to give you a heads up.
I tell you, it was wise to do it, but I forgot to turn it off. Thank you very much, Dr. Slay. And thank you for that summation of the business of the commission. I was remiss, I forgot to recognize that Dr. Slay is the head of a very small staff that makes up the commission and does the hard work that puts together all the statistics and the information that's available to the public and practitioners, and does a phenomenal job in collating information taken from all 3 corners of the state, making it into usable and understandable information that can then be shared and used for research by all. So to the staff members who are here, thank you very much for your contribution and continued hard work. With that, I believe at this point, we should move on to the public speakers for tonight. And calling them in no particular order other than the order that I took off the email. The first speaker that we have signed up is Judge Philip Kroom, who is here individually. Let me make that very clear, not in his professional capacity, but as an individual and a member of MAJOR, the Maryland Alliance for Justice Reform. So, Judge Kroom.
Thank you, Judge Wilson. So, Maryland Alliance for Justice Reform that brings me to this meeting, I should say, is a bipartisan nonprofit, all volunteer organization. We're happy this year to add former Chief Judge Bell as one of our honorary co-chairs, along with former Governor Ehrlich. The group has a lot of professionals, attorneys, judges, folks who've worked in the corrections system, as well as returning citizens. One of the biggest issues that we have talked about for the past year or so was brought up to us by a study from the Justice Policy Institute. Justice Policy Institute is a national organization, but because they're located in Maryland, they take a special interest in our state. And their study that they came out with in November of 2019 was one that compared the disproportional involvement of Black Marylanders in our criminal justice system with that of whites, Latinos, other groups. And what that study found, to our distress, is that Maryland's incarceration of African Americans, especially men, young men, is substantially higher than any other state in the United States, including Mississippi, South Carolina, Georgia, any other state that you might imagine was disproportionate. The population of African Americans in Maryland is only 31%, but the percentage that we have incarcerated is over 71%, more than double. And if you take African Americans who are in our state prisons serving sentences that are longer, 10 years or more, the percentage goes up even higher to be something like 84% or greater. So our group and many others have been discussing why is that Maryland is so disproportionate. And we have had some panel discussions in Prince George's County, in Baltimore County by Zoom. The one in Baltimore County, notably, well, both counties had the state's attorney, the elected state's attorney, participate, as well as other stakeholders. And in both instances, the state's attorney said that they would be willing to participate in a survey of how their practices might result in this disproportionate racial impact. Scott Schellenberger, the state's attorney for Baltimore County, said, of course, he might need extra staff or funding for this, the kind of thing that Scott often says. But with further discussion, thought that occurred to us is that to do a study of plea agreements and what, if any, impact they have on this disproportionate impact is something that is uniquely possible and would be easy, comparatively speaking, for the Sentencing Guidelines Commission. Obviously, on our worksheets, the Sentencing Guidelines Commission collects the data, which includes the racial background or ethnic background, be it Black or white, and I believe there's a space for Latino or Hispanic now. But the information which is collected currently on plea agreements is actually much more limited than what we would like to see. It just currently the only thing collected as to plea agreements is if there was a plea agreement or not, if it was an ABA binding plea or not. But it says this is the account that was pled to. But what it does not tell us that is key, and this is one of three recommendations that our group, Merit Alliance for Justice Reform, or MAJOR, has for the Sentencing Commission tonight. It does not include two things. One is if there were greater, more serious charges that were dropped in order to get this plea agreement. It does not track if there was a recommendation for, in effect, a lower sentence, corrections options, or an alternative to sentencing as part of the plea agreement. So while we know that plea agreements dispose of 90 to 95% of all of our criminal cases in Maryland and all around the country, we don't know exactly what the impact is of these plea agreements on causing this racial disparity, which puts Maryland at the top of all 50 states in its apparent unfairness or apparent, at any rate, unequal treatment to our Black citizens. So it may be that there are better ways that Professor Soule and that the staff and that the commission could think of to delve into this information. But it does seem to us, to Major, that this is an important part of the commission's job. The enabling legislation that Senator Kelly and the other legislators passed when creating the commission says that the commission is to ensure that sentencing should be fair and proportional and reduce unwarranted disparities, including racial disparities. That is the one disparity that was pointed out particularly in the statute. And without tracking, again, plea agreements, which dispose of 90 to 95% of all of our cases in Maryland, we really don't know what the impact is of these plea agreements and of plea policies on creating this disparity, which is more than double, again, the impact of our population. I may have said enough about that. The one other thing that I wanted to, on behalf of Major, bring up, however, is the question as to violations of probation. Everyone on the commission knows that by administrative decision, the commission years ago decided we're not even going to track violations of probation. There at one point was, I think, an effort to do so, but I think currently it's just written into your regulations and your publications. We don't track violations of probation. But we want to, on behalf of Major, encourage you to possibly revisit that decision for a couple of reasons. One reason is that there's more data now that suggests violations of probation are very important than there was at the time you made this decision years ago. For one thing, the Justice Reinvestment Coordinating Council, before it created recommendations that led to the Justice Reinvestment Act, did a study, and it found at that point that 40% of all of our folks who were going back to incarceration after probation were going back on technical violations, meaning they did not commit a new offense. It was just in the judge's discretion because someone had missed some appointments or didn't make all the payments, perhaps couldn't afford to make all the payments for restitution or drug treatment or something like that. This person should be incarcerated again. 40% is a pretty large number, and the result in the Justice Reinvestment Act was to create a presumption that the sentence imposed should not be a full imposition of the entire suspended sentence, but should either be a small increment of 15, 30, or 45 days, depending if it was a first, second, or third technical. A study done by our group and the public defender and others in the Administrative Office of Courts shows that judges are with predictable frequency not imposing those technical caps, the 15, 30, 45 days. We don't know why. And the Administrative Office of Courts, which has been tracking this, they don't really know why either. There's more than one possible reason. One possible reason is credit for time served, that there's too much pretrial detention, which is causing the judges to inadvertently violate the caps because they didn't get the case into court before the person had served too much time. Is that a problem? If you are a person who is serving the time in pretrial detention, you would think so. You may be losing your job. You may, if you lose your job, lose your housing. It may impact your family. And there is a national study, which is in the written materials we've submitted, which suggests that if someone spends more than 3 days in pretrial detention, their recidivism rate goes up substantially. So this commission should care, even if it's only pretrial detention that's causing that. However, there are studies in other states, such as I think Wisconsin, showing that there's racial disparity in violations of probation, substantial racial disparity. We don't know if that's happening in Maryland because we're not tracking it. So it would be easy to track violations of probation. It could be a very short version of a sentencing guidelines worksheet. So for all of these reasons, we would encourage the commission to look again at the racial disparities issue, look especially at the plea agreement and tracking what is going on in these plea agreements. Is that causing our racial disparities? And again, look carefully at your violations of probation decision and perhaps revisit that decision to do a little better tracking of what is going on in violations of probation, because they can be very important, again, to defendants, their families, to our costs of pretrial detention, as the correctional administrators know. I thank you for listening to these suggestions and recommendations. I would, if anyone has questions, I would be happy to respond to questions.
And thank you, Judge Kroom. Are there any questions from the commission members? No. Okay.
Yes, I have one question.
Mr. Ziemba?
Yeah, thank you. Judge Karoum, under the Justice Reinvestment Act, and you had mentioned how the changes that affected changing what had previously been almost unlimited discretion on the part of the judge in sentencing for a violation of probation and creating these categories of technical violations. And the technical violations are supposed to carry certain terms of punishment depending on whether it's a first or second or third, but it allows for the judge to depart from that. The judge can, and you mentioned this as well, that the judge can depart for that for reasons of public safety or safety of the victim or safety of the witness. Do you know if that is being, if the incidents where this is happening, if that is being collected, tracked, if there's any data that's being collected on how often this happens?
Yeah, when there was a group, including someone from your office and Professor Colbert from the University of Maryland Law School, that took this issue to the Rules Committee and to the Court of Appeals, asking to work on the pretrial detention problem. And at that point, when we went, that was in 2019, we got data that had been compiled by the Administrative Office of Courts from October of 2017 to October of 2018. And they didn't really deliberately track it. They had it looked like just an employee had been tasked to have a spreadsheet and pull anything they could off of a hearing sheet, maybe if the hearing sheet said something, but it was not done in a systematic way. I can share with you the spreadsheet that AOC sent to us, and you can see it yourself. But it would be really easy for the Sentencing Guidelines Commission to just create little check boxes like the departure reasons that you have on the current guidelines for non-VOP, for original sentencing, which say, did you exceed the guidelines? Did you go below the guidelines? Which of these reasons applied? Check the box. You can insert more information if there's a reason. You could do exactly that with the technical VOPs, and it would take no more time.
Thank you.
Senator Kelly, did you have a question? Oh, wait, you're still muted.
Okay, thank you.
Oh, thank you.
And Judge Karoum, if some of the other states that are doing better, and it seems like everybody is in that regard, than we are, if you could look at variables that you cite here as making us an outlier, and tell us if there are reports or publications regarding how those same issues are handled. So we've got some other models we could look at from at least 2 or 3 other states.
Yes, so I can, and I think there are links in the written testimony I sent. I don't know if the form that you have them allows you to click that link and go there. There is a study in Massachusetts that was done by Harvard University of their disparate racial impacts. And they had some data that they had collected that was interesting, but they had not collected enough to say this is definitively the problem. In Wisconsin, they have done a study which is also still in progress and which came up interestingly with a different explanation than the Massachusetts study. In one of those states, they thought the problem mostly was caused by the police overcharging in the beginning. And then because you had so many huge charges in the beginning against African Americans, when they got deeper into the system, that same disparity followed them. But in the other state, and I'm apologize, I'm not remembering which is which, they thought that it was deeper in the system. One of the reasons that it may be, that the charging, even if the state changes the charges, that the original charge is important, is because the bail decision for pretrial detention or release, and now even when we don't have money bail, this decision to retain someone in custody may depend on what the original charge was. If the original charge is murder instead of manslaughter, you're way more likely to spend time in pretrial detention. If the original charge was possession with intent to distribute cocaine rather than simple possession of cocaine, you're way more likely to end up staying in custody. So the bottom line is, shockingly, I have not found other states that are doing a great job of this, so that Maryland is maybe just in as good a position as Massachusetts or Wisconsin or these other states that are starting to look at it, or maybe a better position in the sense that we have this statistic collecting system in our guidelines worksheets that we're not entirely using. But I think if we did use it, that a year from now or 18 months from now, we could have a lot of data that would really help us triangulate and figure out where most of the problem is happening.
We probably would need some kind of a fiscal note. I'll just say that because our staff is lean and mean, given what we've charged them with doing already. And so I'd like to talk to you later, maybe offline, about others that could help
We'd be happy to do that. I have lots of confidence in David Soule, though. I think he and his staff are extremely talented, and they can.
Well, they're talented, all right. You didn't give them that much help. Thank you.
Thank you.
Judge Wilson, you are.
Any other questions for Judge Karoum? Yep.
That's it.
Okay. All right. Well, Judge Karoum, thank you very much for your continued efforts in this field and for the documents that you and Major have filed. They are very good reading.
Thank
and
you.
Very well researched. So thank you.
I'll make sure the AOC spreadsheet on technical VOPs goes to David. If it's not already an attachment, I'll make sure he has it.
Okay. Thank you very much.
Thank you.
Okay, the next speaker I listed is Joyce King, Frederick County State's Attorney's Office.
Hi, good evening, Judge Wilson and distinguished commissioners. My name is Joyce King. I'm Chief Counsel at the Frederick County State's Attorney's Office. I've been prosecuting internet crimes against children for about 7 years, and I'm here this evening to address you all regarding the difficult topic of online sexual exploitation of children. Before I get into it, I do want to thank Dr. Soule for his time, patience, and guidance in assisting me throughout this process and the best approach to advocate this issue before you all. I know that you all have received my written testimony and some of the research it doesn't sound as in-depth as Judge Karim's research, but I did try to cite some credible sources and give you all some statistics to back our request. So basically, I'm here before you on behalf of the Frederick County Cyber Crimes Task Force, as well as the Maryland States Attorneys Association, to ask the commission to consider raising the sentencing guidelines for internet crimes against children, especially during this global pandemic. Online sexual exploitation and abuse is on the rise, given the isolation and number of children on the internet. The National Center of Missing and Exploited Children reported, I think, 106% increase in cyber tips reports during this period of time. So my letter, as you all, and I'll just summarize its contents, is asking for an increase for particularly the offenses here in Maryland related to child pornography and sexual solicitation of a minor. And the basis for the request is really threefold. The first being that in the last 2 years, the legislature has really taken a lot of actions to expand and amend our state statutes to bring them in line with federal standards. And the legislature has really realized the growing need, the necessity and the seriousness of these crimes, and has escalated it. However, the sentencing has been left behind. While the increase in penalties were not increased, we believe the expansion in the law does merit an increase in the guidelines. Right now, first-time offenders for these offenses, have scores that are allowing them to receive probation before judgment, which, as you all know, allows them to avoid the registration requirements as well as get the offense completely expunged, which, given the nature of the offenses, is unconscionable and I believe contradictory to the movement and progress that we've made in the legislature. The second is, during my discussions with Dr. Soule, we discussed how the guidelines really didn't appreciate and maybe consider the evolving and permanent nature of the internet. I believe that it's time to reconsider and maybe update the guidelines to really reflect the appropriate seriousness of these offenses. So twofold, I made some specific suggestions in my letter to you all, is that to increase the seriousness category. Right now, child pornography or possession of child pornography is a category 5, and we're requesting the commission to increase it to a category 4. Distribution of child pornography and sexual solicitation of a minor are category 4s, and we wish to increase it to category 3. Dr. Soule brought up a good point that currently all offenses that are categorized 5 through 7 all receive the same amount of points in calculating the offense score, which is just 1 point. So you're basically lumping in possession of child pornography to much less serious crimes, such as disturbing the peace and disorderly conduct. Secondly, the other suggestion we made was the offense scoring. Right now, the victim injury we put as temporary. We were hoping for an exception to this portion of the guidelines manual to seek an exception for victim injury regarding internet crimes because of its permanent nature. Every time images are viewed, possessed, distributed, those children in those images, this permanent documentation and record of this child's abuse really effectively re-victimizes them over and over and over again. So we would argue that that is permanent injury, and I did cite some research to that effect. Additionally, the federal guidelines take into consideration other aggravating factors that our guidelines just miss, such as the number of images. It doesn't matter whether you have 1 or 5,000, which I have personally seen on some of these computer systems. There's no way to aggravate the sentence. The nature and the number of images, and most shockingly is the age of the victim. Someone who is looking at child pornography of a 15-year-old gets the same offense score as someone who's looking at the rape of an infant. And we believe that, some sort of aggravating factors are warranted in these types of cases. The last, justification for our request is really distinguishing these offenders from other offenders in our system. The dangers of online sex offenders. There's been a lot of research done regarding the correlation of hands-on offenses with online offenders, the progressive nature of these offenders, the recidivism of these offenders. And I think all of that should really be taken into consideration and distinguish this body of offenders from others. During this time of COVID and this pandemic, the numbers have really been astonishing. I mean, the ballooning nature of this problem already existed before COVID and really has just been exacerbated. And I really appreciate the commission taking the time to hear me out, because this, and I've said this before the legislature the past 2 years, I know this is an uncomfortable topic. It's something that's not often covered by the media. We just had a press conference yesterday, and it was probably one of the first press conferences where there was just one question, because people really don't know what to ask or how to ask it, because no one wants to talk about this. And what happens is the victims in these cases become, marginalized and minimized. And, I've heard judges say things like, this is a victimless crime, or this individual didn't actually hurt anyone. And that's just not true. The thousands and actually millions of victims in these photos and images will sometimes never be rescued, and that's really what we're trying to prevent, is that their continued abuse, their continued sexual abuse. So I think that really sums up my written testimony, and I'd be happy to take any questions. I know I put pressure on you guys to ask me questions now, so I'm happy to respond.
Thank you, Ms. King. And are there questions from any of the members of the commission? Yes, Senator.
I guess it's almost more of a comment. I really do appreciate your bringing this to our attention. We probably are not the right entity to do the basic work that obviously needs to be done, because our job is to reflect back to everybody in the system and to the public what the policies and actions and proclivities of the actors who have responsibility in the system, what they are doing. You mentioned the legislature a few minutes ago, and it sounds to me like that's where you need to go back, is to the legislature. And people like Judge Karoum do a lot of testifying in front of members of the committees of jurisdiction. And I certainly am very interested, and I don't disagree with anything you said regarding how important of these considerations are and the impact that they have. But we actually don't determine what a sentence ought to be. We reflect back to everybody in the system what the averages in a way are. And so that people in the system and the public can tell what it is that is happening and how it is happening. So I know that might be a frustration to hear that, but I'd be willing to talk to you. I'm sure there are many others in the General Assembly that would be willing, and some on better committees than mine, to help with that. So I'm glad you brought it to us, but I'm not sure we can do anything about it except wait until the system reflects the greater justice that you are recommending.
Thank you, Senator. Judge Avery, I think you had a question.
Thank you, Judge Wilson, and thank you, Ms. King, for being here tonight and for giving us your requests. I think that what you've presented to us is now in the record of our meeting, and to the extent that we have any policy control over the requests that you've made, we will examine them and we will consider them within this commission. And the other thing I wanted to say is I want to thank you for your service. What you do is extremely hard, and it creates a lot of trauma, even just being involved in the work that you do. And I just want you to know, I mean, I think I can speak on behalf of all of us that the work that you're doing, especially during this time, is very difficult and very much appreciated by us and by the public.
Thank you very much.
Thank you, Judge Avery. Anyone else? Yes, Mr. DiLeonardo.
Thank you. So I do think one of the things that we do control is classification of an offense and what's an appropriate category. I agree, Senator Keller, we don't decide the sentence. But if I could, I ask David, when this classification was done previously, it sounds, based on what was presented, there's been additional factors placed in the statute. What would be the process for us to re-examine or have staff re-examine, take a look at whether that classification is still an appropriate classification?
Sure. I mean, I think it's as simple as asking the guidelines subcommittee to take up that review.
I mean, and how long would that take? Just to examine to see whether or not the staff's opinion is that a classification is still an appropriate one, 5 or 4. Because certainly a lot has changed since the previous class.
Yeah, so we can certainly, that's something we can do relatively easily. We can make a comparison just as we do whenever new legislation is passed that, creates a new penalty or amends the existing penalty. What we would do is, look at that and see how that compares to what we call comparable offenses. So that's an analysis that we can certainly put together at the request of the commission, of course.
Well, so Senator Kelly, perhaps since we're on the subcommittee, if we could at least take a look at when it was originally classified versus what, if any, changes now, would that work for you, that we could at least take a look at that?
You're live, Senator Kelly. You're good.
Okay. I'm all for what she wants done. I'm simply saying that the way I look at our job, we are not the ones to determine what the sentence ought to be. And you're saying that many sentences are inappropriate, and you made your case about, as far as I'm concerned. But I'm just saying that we probably need to look at where the responsibility really lies for having sentences that are more appropriate given the harm done and the nature of the offenses that you're talking about. And that was all I was saying.
Well, I certainly would ask. I think that would be
appropriate. Many times citizens do come and they really think we can solve the problem of how sentencing is happening and we are really reflecting back to everybody what in fact is happening. And sometimes having it reflected back will be enough for others because you focus on that to decide. But people are so busy doing their portion of what they do in the system that it's probably going to take some real work. And I'm simply saying the legislature ought to be taking a look at that.
Again, I certainly think it's appropriate to take a look at whether we classify it appropriately. I agree. What the ultimate sentencing is not an issue that we can change. Certainly we can change the way.
Yeah, if I may, I mean, I think what I'm hearing is I'm not disagreeing with anything. I think certainly the penalties are driven by the legislature, but we do have it within our purview as a commission to reconsider the classification for those offenses. And we can use data when we're doing that to also see how those classifications align with what we're seeing for the sentences for similarly classified offenses. So I do think that is we do have that area that it is completely appropriate because we regularly do that every year. We classify offenses. So I do think it is appropriate for the commission to look at that and also to be driven by the data that we have available.
Can I make a brief comment?
Yes, Mr. Fincy.
Thank you, Judge. Ms. King, I was very impressed with what you had to say. You and I have never met, but as you may have heard during the introductions, I'm a private criminal defense attorney, handle the kinds of cases that you're referring to on a frequent basis, unfortunately. But one of the things I have found, and this is coming from judges on the bench, is that some of the, I guess, collateral consequences of convictions have led many members of the bench to look at their lack of discretion in doing things such as assigning someone to the sex offender registry for extensive periods of time to motivate the court to grant a probation before judgment disposition in cases which maybe didn't deserve it. So I guess the point I'm making is that there have been many increased consequences of these types of offenses that have gotten to be, in some cases, so draconian that the court has gone the other direction in cases that I've handled because of that. So, I mean, I just want to give you a second perspective on what some of us private defense attorneys and public defenders see on a daily basis in these cases.
Thank you, Mr. Fincy. Any other questions or comments from the commission?
Judge Wilson, just for my understanding,
Yes,
if
Ms. King.
Dr. Soule were and his team were to do that study and analysis, is that a formal motion that's done by the commission as a whole, or is that something that would need to be submitted by subcommittee?
Well, the commission could decide as it's on its whole whether to have that issue researched or not, and then assign it to the subcommittee appropriate task. And I wouldn't say it's too formal of an action, but it's something we can take up in new business.
Thank you so much for your time and patience.
Thank you. And Judge Wilson, that was my intent, was to maybe bring it up in new business as opposed to.
I kind of thought that's where you were going. Thank you.
Judge
Okay.
Wilson,
Yes, ma'am.
just one last comment to Ms. King. I just wanted to also say thank you for your participation in this. As a person who does this work on a daily basis, we appreciate the efforts that you're putting forth, and I'm glad that you brought this information to us tonight. So I am glad that we will be discussing it in new business. So I just want to say thank you.
Thank you, Ms. Miller. Thank you, Ms. King. If there's nothing else, we do have one more speaker tonight I'd like to get to. I know she's been very patiently waiting, but Cheryl Galladay is here. And Ms. Galladay, the floor is yours.
Thank you. Good evening, everybody.
Good evening.
My testimony will address quasi-life sentences and children confined as adults. Maryland sentencing practices can create quasi-life sentences for former prisoners or anyone who was criminally adjudicated. Due to restrictions imposed on their constitutionally guaranteed liberty by criminal sentences, for years, people face challenges rebuilding their lives, which can consume all the life they have left. Releasing a person from a prison or sentencing them to live in community does not equate to freedom. Some of the challenges involve employment, housing, education, expungements, debts, or electronic monitoring. With these challenges, released people essentially face life sentences because their criminal history negatively affects their liberty. Additionally, Maryland should immediately end the practice of sentencing children as adults and placing children in adult prisons. We should also end electronic monitoring for children and limit community supervision to no more than 1 year. To achieve these ends, we need to act now. Maryland does not need to study how sentencing laws cause quasi-life sentences, nor does it need another commission or white paper regarding sentencing children. We simply need to make the changes in the immediate future that are necessary to secure more just and prudent sentencing practices and policies for both adults and children. For example, debts could be forgiven upon release or when sentencing requirements were met. Also, ending the practice of charging the person under court supervision for electronic monitoring would eliminate an expense for them. I didn't have the video on because something's going on strange with it. So I don't really look like that, everybody.
Oh, you must have a virtual background in, and you're sitting in such a way where it puts the virtual background on your face.
Oh, I didn't think about that.
Unless you really are in San Francisco.
That would be nice. But I'm about done. So I want to say in summary that whether Maryland's sentencing laws, policies, or practices are applied as intended or not, quasi-life sentences is a reality traceable to sentencing in the state. And that fact is feeding a system of mass incarceration, both inside prison walls and in our communities. We must change that reality for the citizens who have been victimized by Maryland criminal sentences, and actually for all of us. Thank you for hearing from me.
Well, thank you, Ms. Galladay. Again, let me open the floor to the commission members if there are any questions or comments for Ms. Galladay. Senator Kelly, I think you just turned your microphone off, actually.
Okay, thank you.
There, go ahead.
I just want you to know that in talking to colleagues of mine in both houses, there are bills that you're going to be interested in that address some of what you've just spoken about, not all of it, but some of it in terms of the sentencing of children. I think you're going to find a number of things before us. You'll probably want to testify at that time and make sure that the committees of jurisdiction hear your position.
That'd be great. I mean, it's sad that I think Maryland is one of a dozen states in the union that still sentences children in adult prisons. We're better than that.
Thank you, Ms. Galladay. Is there any other comment or question from the commission? And Ms. Galladay, I'll echo the senator's comments as a former member of the legislature as well. This is an issue that is brought up on a regular basis and researched and debated. And I'll just say the discussion continues.
Thank you.
And thank you very much for bringing that to our attention. Okay, if there are no further questions, I believe that's all of the speakers, Dr. Saleh. Oh, now your mute's on.
Sorry about that. Yes, there was originally a fourth speaker who registered. He emailed me just prior to the start of the meeting and said he was unable to participate. Of course, he did provide written comments. That's Mr. Sanderson, and they were forwarded to the commission.
Okay. Well, thank you very much. That concludes then the public comment portion of today's meeting. For any member of the public that is participating in this, I thank you very much for participating. This commission really is designed and was created for the purposes of ensuring that the public can have confidence in the criminal justice sentencing system, as well as, of course, to make sure that the criminal justice system across the state understands each other. Because even though we're not a particularly large state, it is still very easy to get regionalized and to simply be unaware of what happens in other portions of the state. And the commission solves that, at least on this issue, by collating information from across the state and making us all more intelligent and better members of that system. So I guess I'll ask the commission members, are you ready to continue into the regular meeting that's scheduled for tonight at this time? Or do you wish, if anyone wishes a break, they certainly can step away. There will be a couple action items tonight. However, we can make sure that you're present for that. So is everyone ready just to continue? Okay, hearing no objection. Dr. Saleh, let's see. I guess the first thing for us is we still have a quorum. Is that correct?
Correct.
Okay, then approval of the minutes from the September meeting. Did everyone have a chance to review those minutes prior to the meeting tonight? Yeah. And what we'll be doing for voting, just to make it easier, is there'll be voting in the negative. So basically, I'll ask for any nays. If there are nays, then we'll count those. Otherwise, we'll not be taking a yay vote. It just seems to be easier on these virtual meetings.
Sure.
So are there any corrections or additions that anyone wishes to make to those minutes? All right, hearing none, I'll accept a motion.
I'll make a motion to accept the motion. I'll second.
Okay, so motion's been made, seconded. Any further discussion? Hearing none. Is there any objection to the adoption of the minutes as presented? All right, seeing none, they are adopted. All right, let's see. Looks like a guideline subcommittee report. Judge?
All right, thank you. So the guidelines subcommittee did meet on November 30th, and we had an ever lively conversation about the issue of ABA pleas and what we are going to call them and how we are going to define them. So I'm going to give that very general statement, and then I'm going to ask David, Dr. Soule, to review the recommendations that we're making and the thought process that went into that.
Sure, thank you, Judge Avery. So I refer you to the memorandum labeled Proposed Revisions to ABA Plea Definition and Compliance Rule, and the corresponding supplemental information on ABA pleas. So 2 questions regarding ABA pleas were considered. First, should the Sentencing Commission clarify the definition of an ABA plea and/or provide specific examples of what constitutes an ABA plea? The second question was, should sentencing events resolved by an ABA plea continue to be deemed compliant, guidelines compliant, even if the sentence is outside of the recommended sentencing guidelines range? So the guidelines subcommittee considered these questions at its 3 last meetings in June and August, and as Judge Avery noted, most recently on November 30th. The subcommittee discussions included a review of definitions of binding plea agreements from other jurisdictions, as well as Maryland case law. The subcommittee also reviewed data on how sentences for sentencing events resolved by an ABA plea compare with sentences for sentencing events not resolved by an ABA plea in the last 3 calendar years, 2017 through 2019. As a reference for today's meeting, we once again distributed the document titled Supplemental Information on ABA Pleas. That document was previously provided to this commission meeting in September. It summarizes how other states and jurisdictions define the ABA pleas and binding pleas, and it summarizes the data analysis that was reviewed by the subcommittee. Again, that was previously presented to all of you in September. We're just providing it as a reference as needed today. The memorandum that was presented today adds to the previously distributed materials because it presents recommendations from the subcommittee for proposed revisions to the guidelines manual and COMAR. So the first thing that the commission took up is, or excuse me, the subcommittee took up is term clarification. That is whether the commission should clarify, as we were considering whether the commission should clarify the definition of what constitutes an ABA plea. But before we could get into that question, we really got into a discussion about the term itself. The subcommittee unilaterally agreed that the term ABA plea is not universally known by court staff and other criminal justice practitioners, and therefore we thought it should be replaced with a more intuitive term. And the subcommittee considered a couple different options, including first option that was considered was a 3-party binding plea agreement, because they thought that's really what constituted, the name itself constituted what we were really talking about in terms of binding pleas. However, the subcommittee also decided that they were going to recommend the definition for this type of plea should describe a plea that requires a greater level of specificity in terms of the sentence. And I will describe those proposed revisions further in a few minutes. But because of the decision to change that definition, the type of sentence that is guidelines compliant, and that the definition may be going beyond the Maryland rule that speaks to what a binding plea is, the subcommittee questioned whether the term 3-party binding plea was clearly distinguishable from simply a binding plea that is already staked out in Maryland Rule 4-243. While the subcommittee believes it's certainly appropriate and relevant for the commission to speak to the conditions of what constitutes a guidelines compliant plea, the subcommittee thought the commission needed to be careful to distinguish what is a binding plea per Maryland Rule 4-243 and what is a guidelines compliant binding plea. So to that point, the subcommittee considered other terms, maybe calling this a guidelines compliant plea. However, there was concern expressed that the term guidelines compliant plea may be confusing, and that law clerks or administrative assistants inevitably will may not read the instructions that go along with it and may select the disposition label guidelines compliant plea only if the sentence is shown to be strictly within the guidelines range. And the staff had really emphasized to the subcommittee that court staff need to be able to easily identify the disposition type, and we wanted to make it easier for them to do so, not harder. One of the things that we do know is that cases are being identified as what we currently call an ABA plea that are not ABA pleas. And so we really wanted to come up with some clarity to help eliminate any confusion that may exist there. So the subcommittee ultimately settled on the term, calling it a Maryland binding plea, and we completed the meeting and came to that agreement. As the staff sometimes does, we further contemplated that term amongst ourselves after the meeting, and I apologize for this, but I have run it by the subcommittee. The staff expressed concern about using the term Maryland binding plea because we thought that it may imply that the legislature or the court or the Bar Association had a hand somehow in crafting that specific type of definition. And so we ultimately are going to ask the subcommittee to potentially endorse using the term MSCCSP binding plea, which I realize is a mouthful, but that is the acronym for the Maryland State Commission on Criminal Sentencing Policy. The rationale is that MSCCSP binding plea is a specific nod to the guidelines and the Sentencing Commission, but without implying that a sentence is within the guidelines range. So that's the term we get. We can discuss that further, but I think we should go into what the definition revisions are and kind of consider them in their totality. So the subcommittee reviewed definitions of a binding plea agreement from other jurisdictions, as well as relevant Maryland case law, to recommend proposed revisions based on that information. So those revisions are presented to you starting on page 3 of the memorandum. And there's really 3 notable revisions in that definition that I want to point out. First, the proposed revision offers clarifying language to confirm that a binding plea involves agreement from all 3 parties. And that point is now emphasized by including new language as illustrated in the underlined text in the first section of the definition that's provided in Chapter 2 of the Guidelines Manual and mirrored in COMAR at 1422.01.02b7. Specifically, it would read that a Maryland or potentially MSCCS binding plea agreement is a plea agreement presented to the court in agreement by an attorney from the government and the defendant's attorney or the defendant when proceeding pro se, and so forth. So that's the first revision. The subcommittee, I also want to note that the proposed language strikes or judicial action from the end of the first sentence and instead inserts an and between particular sentence and disposition. And this recommendation was made because the inclusion of the term or other judicial action in the original definition leaves open the possibility that a particular sentence could technically qualify as an ABA plea agreement and therefore be deemed a guidelines compliant sentence based solely on the fact that the court approved some particular action, but not necessarily the corresponding sentence or disposition. So maybe they improved for example, a scenario where they approved a particular action like an agreement to consider a sentence reduction at a later point if the defendant successfully completed substance abuse treatment while confined. But then the court didn't agree to the specific length of incarceration as presented by the state or the defense. In that scenario, the court approved a judicial action. In other words, the agreement to reconsider the sentence upon completion of substance abuse treatment, but the court did not approve the sentence length. And based on the original definition, that hypothetical would still be considered a guidelines compliant plea. So the subcommittee believes that for the purpose of the relevance to the guidelines, the commission definition of what constitutes a guidelines compliant plea should only be concerned with the particular sentence and the disposition. The second component of the revisions is the addition of language in the last 2 sentences to emphasize that the court maintains discretion to accept or reject plea agreement and it is not binding, meaning the agreement is not binding on the court until it accepts the plea. And then finally, the third and final proposed revision is to the definition reflects the subcommittee agreement that the definition of what constitutes a guidelines compliant plea agreement should be tightened, and to specify, to specifically indicate an agreement as to the active time, if any, and not merely a sentencing cap or range. Specifically, the proposed revision adds a new second sentence to read, a Maryland or MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. So I think I'll stop there because I will present those revisions as the first portion of the recommendations of the guidelines subcommittee. Judge Wilson, you are now on mute.
Yeah. Judge Avery, then are you asking for a motion based on Dr. Slay's report?
I would be. Yes.
Okay, well, go ahead. If you can spell it out for the commission, it's a great time to do it. And then we'll open the floor for conversation, of course.
Okay, well, essentially we are seeking the approval, a motion to approve the recommendations that are laid out in the memo that were described by Dr. Soule.
And I'll second the motion.
Okay, and then floor is open for discussion. Okay, if none, if everyone's prepared to vote, again, we'll just call for the vote in the negative. So is there anyone who—
May I interject just 1 second, Judge Wilson, just to clarify, is the motion to adopt the term the amended term as proposed by staff, which would just be to replace Maryland binding plea agreement with MSCCSP binding plea agreement?
Well, yes, I would propose that as the amended recommendation to the commission. I guess I did expect a little more discussion about it, but I'm happy if everyone is in agreement. We did discuss this really in depth in our subcommittee, and I understand that the initials for the commission, it could be a little cumbersome, but I think ultimately people will refer to this as a commission binding plea. People will come up with their own handle for it. So I don't have a problem with it. And I think upon a very considered reflection that this does legally and factually solve a problem that we have had. So I appreciate the support of the commission.
Mr. Zaremba. I'm sorry, Mr. Zaremba, I saw your hand up. I'm sorry.
Yes, yeah, thank you. No, I just wanted to, voice my agreement. I think the amended language really clarifies things. If the intent is to define this binding plea as only that which contains a particular sentence and not a range of sentences, I think it can be confusing to call it a Maryland binding plea, because under 4243, a judge can bind to a range of sentences. So I think this provides clarity.
Thank you.
If it's in order, I second the motion.
Okay. Any further discussion? All right. Again, in the negative, any objection, any opposition to the motion as presented? All right. Seeing none. Good job, Judge Avery.
What can I say? Thanks, David.
So I do want to just, the next recommendation doesn't require an action, but I do want to just point out the recommendation that the subcommittee discussed the binding plea, what we're now calling the MSCCSP binding plea agreement rule. The subcommittee reviewed whether sentencing events resolved by a MSCCS binding plea agreement should continue to be deemed compliant, even if the sentence is outside the guidelines range. And the subcommittee recommends retaining this binding plea compliance rule as long as the disposition type meets the commission's now revised definition of a MSCCSP binding plea agreement. The subcommittee also noted that the commission will next conduct a cell-by-cell compliance analysis in 2021. And please recall that the analysis was postponed because of the passage of the Justice Reinvestment Act that changed maximum penalties for quite a number of drug and property offenses effective October 1, 2017. So in 2021, the commission will then have 3 years of data to be able to analyze those sentences post JRA's implementation. And so the commission expects to, that at the time that there is a possibility that we may be amending guidelines ranges based on the data, if that's what the data is telling us. So in that scenario, ultimately, it's possible that some of the sentences that are adjudicated via binding plea that are currently outside the guidelines may become guidelines compliant because of the amendment to keep the ranges consistent with sentencing practices. So there is no recommendation. The recommendation is to keep, so there doesn't need to be any action on this, but I just wanted to share that that was the recommendation of the subcommittee. And I will loop that in with the final topic that was that the subcommittee did also make recommendations for how to report the commission's deliberations about this topic. As you may recall, the commission responded to House Bill 1458 from the previous the 2020 legislative session. That was a bill, if you may recall, which proposed eliminating the ABA compliance rule. The commission at the time asked the legislature, to defer on any action to allow the commission to study the issue and report its findings to the legislature for before the 2021 General Assembly session. So the subcommittee recommends that the commission will update the legislature on the actions taken by the commission, much of which comes from tonight, and that our plan is to revise the definition of it and tighten it up, and that also to let the legislature know that we are planning to do the cell-by-cell analysis in 2021 that will be revisiting the guidelines ranges. So we plan to do so by sending a letter to the respective chairs of the Senate Judicial Proceedings Committee and our own Delegate Klippinger as the chair of the House Judiciary Committee, as well as the two presiding officers from both chambers. So I present that as also the recommendation for how the commission will report this activity.
I guess I would only add that, David, I appreciate you summarizing that. Obviously, we're not revisiting the compliance rule with regard to these pleas at this time, but I think that the work that we've done has, in a very objective and nonpartisan way, tightened up some of the issues around this policy that we have in such a way that I think it answers some of the legitimate criticism as to why we are deeming these pleas to be guidelines compliant. And I appreciate the work that everyone has done on this, and I hope that the legislature appreciates that we've heard the criticism and that we've addressed some of these issues, and at the same time preserving the underlying purpose of this policy, which I think promotes good sentencing policy, which is to allow for binding pleas to be accepted by a court, and that we believe that is important for the policy mission of this commission.
Thank you, Judge Avery. Mr. DiNardo?
Thank you. David, I just have a question. I can never quite remember. So what is the timeline for this to be rolled out?
It's a good question. So it's typically about a 4-month timeline. The staff will submit these proposed revisions almost immediately because we have to, because there's a moratorium on submitting at the beginning of the legislative session. So we will get them in right away. So what that means is roughly March 1, April 1, I would expect this to be adopted in Comar.
So my recommendation might be, and certainly on behalf of the association, I would invite you to speak to us, but I think it could be really important for us to educate all the stakeholders as to this because much of the practice that has developed has been based on things like that to explain that there's a procedural change. Because, for example, I know from the prosecutor's side, I expect that we will have more judges wanting us to put a number as opposed to a range, especially if that sentence is going to fall outside of it. So I just think it might be a good thought process if we're talking about 4 months out, kind of at least educating the stakeholders.
Brian, I wholeheartedly agree. I think that's an excellent point, that the educational component of this is critical. And so I will probably be turning to you about, what is the best way to get that information out to the State's Attorneys Association, and the same with the judges and the defense attorneys, to make sure everyone's on the same page.
Yeah, likewise, maybe Judge Wilson and I can help with any judicial education on this point as well. I mean, if it's a Zoom, or if we do it actually through our judicial college.
Any other comment on that topic from the subcommittee? Or, Judge Avery, did you have anything else to report from the subcommittee?
That's all. Thank you.
Well said. Thank you. Okay, moving forward, the next topic is to hear a report on the criminal justice community survey from Dr. Najak. There she is, Najak. There you are. Okay.
Yes. Thank you, Judge Wilson. So I just wanted to briefly provide an update on the survey and analysis. As was reported previously, the MSCCSP, with assistance from the AOC, developed an online survey to solicit feedback from members of the Maryland criminal justice community on both the guidelines and the activities of the commission. The survey consisted of a combination of both multiple choice and open-ended questions, taking approximately 5 minutes to complete. This past May, a link to the online survey was emailed to all circuit court judges, each office of the state's attorney, the office of the attorney general, each office of the public defender, and a sample of private criminal defense attorneys. 223 survey invitations were sent and 103 completed surveys were received, which amounts to a 46.2% response rate. Including in the media materials for tonight that were provided via email is a report from staff on the survey results. The survey questions are provided in the appendix of the report, and the report includes details on response rates by position and circuit, as well as summarizing responses to each survey question. And I would note that the responses to the open-ended questions were reviewed for common themes, and similar responses to those items were categorized together. At this time, the staff is requesting that commissioners review the report following tonight's meeting and contact staff with any comments, questions, or potential action items based on the survey feedback. As is noted in the last section of the report, which begins on page 15, the staff identified multiple action items that could be addressed immediately to improve commission resources and to better inform practitioners regarding the guidelines. And so the staff has already completed or initiated a number of items, including amending the commission's website homepage to include a flyout menu and also a direct link to training materials, initiating work on the website and the MAGS application to make both mobile friendly so they can be used on iPads, cell phones, etc. Increasing training availability by providing multiple online webinars and posting webinar recording to our YouTube channel. Updating the guidelines training webinar to provide instruction and clarification regarding some of the issues raised by the survey respondents. Publishing periodic snapshot reports, which David referenced earlier, on sentencing trends. And finally, following up with respondents who provided their contact information in the survey and had specific questions or concerns that staff were able to address. So I will just conclude by noting that additional steps are expected to be taken once commissioners have had an opportunity to review the survey report and to provide recommended action areas. And so staff would welcome those suggestions. Thanks.
Thank you, Doctor. Are there any questions from the commission or comments? All right. Well, thank you very much. We will take a more deep, in-depth look at that and get back to you with comments and perhaps any other questions as soon as possible. Thank you for your work. Okay, looks like Dr. Soleil, you're up. Executive Director report.
Thank you. So I have 6 items to review. So the first is sentencing guidelines trainings and judiciary feedback meetings. The staff continues to work to provide training on the sentencing guidelines. Since the start of the COVID-19 pandemic, these trainings have all been conducted via online video conference or webinar. On September 22nd, I conducted a webinar for the Judicial College titled Making Informed Sentencing Decisions, Enhancing Sentencing Guidelines and Policy Knowledge. On September 29th, the Commission's training coordinator, Catherine Pembroke, provided a sentencing guidelines and MAGS orientation training for the Baltimore City State's Attorney's Office. Catherine also recently recorded a webinar that is to be included for the new law clerk's orientation. Regarding judiciary feedback meetings in November, I met with the judges and court staff in Allegheny, Garrett, Harford, and St. Mary's counties to conduct feedback meetings and provide sentencing guidelines data. These meetings, as I kind of noted in the presentation during the public comments hearing, are really an excellent opportunity for me to talk about the recent guidelines amendments and the works and activities of the Sentencing Commission, but also really to get input from the judges, to hear about them and to have hear if they have any concerns or if there's areas of the guidelines that they think the commission should be looking at. I have an additional feedback meeting is scheduled in December with Judge Wilson's group in Washington County. Finally, I want to note that the staff met with the chair of the Maryland State Bar Association Criminal Law and Practice section, and we are working to plan a guidelines webinar that would be offered in conjunction with the State Bar Association. We reached out to the Bar Association to offer this training. We are hoping that they will agree to offer continuing learning education CLE credits associated with the training, because we kind of wanted added incentive for participation. So hopefully maybe at the next commission meeting, I may have an update on that, or maybe hopefully we've provided the training by that time. The second item that I want to report on is just a review of the protocol for the commission's response to legislative proposals. I thought this was important to revisit again with the upcoming General Assembly session starting next month. For those who've been with the commission, in 2019, we adopted a protocol for responding to legislative proposals. During the last few sessions, there have been bills that potentially affect the commission. And so the commission does not typically meet during the legislative session. And because of that, we decided to adopt a policy to guide our response to legislation that directly affects the sentencing guidelines and or the operation of the Sentencing Commission. So there was a document that I provided to you that was distributed that was titled Policy for the MSCC Response to Legislative Proposals. This is nothing new. This is the same policy that we did follow last year. The policy was that the staff will identify any bills, notify the commission promptly. If we feel like there's a need to have a conference call for the full commission to take a position, we will potentially schedule that. Of course, it could be a Zoom webinar as well. And I guess we were a little bit ahead of the times in that, since we were doing those that way last year prior to the start of the pandemic. But ultimately, we have this proposal, which I presented to you, and I just wanted to really just check in and make sure for our new commissioners, if they had any questions about this proposal, but that we have this plan in place should legislation be introduced again in the upcoming session. Okay, I don't think I see any questions. That's great. The third item that I want to update on is the task force to study crime classifications and penalties. Chapter 372 of 2019 established this task force. As by virtue of my position as director of the commission, I am an appointed member of the task force, and so it's my intention to update the commission on the activities of that task force. We held 2 meetings in 2019. At the first meeting, the task force membership elected Senator Mary Washington as the chair. The task force most recently met on November 12, 2020. At that meeting, Professor David Jaros from the University of Baltimore School of Law provided a follow-up presentation on the work of a previous committee, the Commission on Criminal Law, that had worked in the 70s to draft a comprehensive revision to the Maryland Criminal Code. The proposed revisions from that committee never came to fruition, but the work may help guide the current task force that is looking at many of the same issues. At the November meeting, we also heard presentations from Judge Daniel Long as the chair of the Justice Reinvestment Oversight Board, also the People's Commission to Decriminalize Maryland, and the National Conference of State Legislatures. The task force worked to prioritize its objectives moving forward and agreed to focus on examining current classification and penalties for criminal laws in Maryland, with really a focus on establishing a clear demarcation between misdemeanor and felony penalties in Maryland. For those of you who may know, Maryland is quite unusual in the fact that the overwhelming majority of states have a demarcation of 1 year, where anything less than 1 year is a misdemeanor and anything greater is a felony. And Maryland has 10-year misdemeanors on the books in our criminal code. And so that was one of the major points of emphasis that this task force would like to address. Finally, the task force agreed to reach out to the legislature to ask for an extension of its work. We didn't meet for a good 6-7 months, in large part because of the pandemic, and so it was delayed because of that. So we plan to ask for an extension of the work through December 2021. And last, but certainly not least, I just want to take this opportunity to ask for input from the members of this commission. I ask that if you, in your own jobs, have, identified oddities about the criminal code, which I know many of us have, I ask that you, please feel free to communicate those with me if there's anything that you need to be addressed, and I can certainly make sure that they are brought to the attention of the task force. The fourth item I want to update is regarding the application of non-suspendable mandatory minimums in MAGs. So recently, the commission received an inquiry from a law clerk who was completing a worksheet in the Maryland Automated Guideline System, or MAGs. The law clerk was attempting to input a sentence of 5 years, suspend all but credit for time served for conspiracy to unlawful use of a firearm in commission of a crime of violence, pursuant to Maryland Criminal Law Article 4-204C. As many as you may know, MAGS is programmed to include several data checks to prevent users from accidentally entering an incorrect or invalid sentence. So for example, a user cannot enter a sentence that exceeds the statutory maximum penalty for a particular offense. Or in this case, it wasn't allowing the user to enter a sentence that was less than the non-suspendable mandatory minimum for the offense. Just as a side note, this is one of the benefits of MAGs that we didn't explicitly anticipate. The data checks built into MAGs have helped to prevent the imposition of illegal sentences on more than one occasion. So that wasn't an intention necessarily, but that's kind of a nice benefit. But returning to the particulars of the specifics of this particular case, MAGs would not allow the law clerk to enter the sentence because it fell below the mandatory minimum of 5 years associated with the offense. But the law clerk contacted us and indicated that she believed the mandatory minimum would not apply as it was a conspiracy, the offense about the conspiracy. So the staff confirmed with the Office of the Attorney General that there is case law that indicates that both conspiracies and attempts are subject to only the maximum punishment for the crime that the person conspired to or attempted to commit. So unless otherwise outlined in statute, conspiracies and attempts are not subject to the non-suspendable mandatory minimums associated with a given offense. Accordingly, the staff documented this issue, and we have submitted a request to our programmers at Department of Public Safety and Correctional Services so that MAGs can be revised to allow users to enter sentences that fall below the mandatory minimum if the offense involves either an attempt or a conspiracy. The fifth item, the annual report. The Commission's annual report is due every year on January 31st. So the 2020 report is due on January 31st, 2021. We've already begun preparations, the staff has, for this report, and we expect to send a draft for your review by January 22nd of 2021. And we ask that you review the report and send your feedback, questions, concerns, directly to me, and we'll review that feedback and incorporate changes so that we can submit the report by the due date. Finally, just another update on the sentencing snapshot. In July, we started publishing the sentencing snapshot, which I noted during the public comments hearing. It's a topical mini report that's intended to provide a quick review of sentencing trends and other topics of interest. The most recent issue examined characteristics of sentences for second-degree assault, sentenced in the circuit court, and that was published in October. Again, I encourage you to review these if you're interested, and if you have topics for suggestion, if you think would be appropriate, to please feel free to share them with Judge Wilson or anyone on the staff.
I can just interject, David. That's very well done. I think that's you and the staff. I think that's. I heard a lot of good feedback.
I appreciate that, Brian. That's very nice to hear. I got to give a shout out to Sarah Bowles on our staff, who is really our lead point of contact for the sentencing snapshot, and she does a great job.
And I would say even the design of it is we're used to looking at such dry material. I really like the way it was.
Well, we appreciate that feedback because we put a lot of thought into that just for that, we wanted to make it more easily digestible, less text and more graphics. So we appreciate that feedback.
Great. Any other comments or questions for Dr. Saleh on his report? If anyone's looked at them, I agree, David. The snapshots are wonderful. They really are.
I appreciate that. Thank you.
Okay. With no comment, moving on. I guess we're up to proposed meeting dates for next year.
Correct. So we a few years ago we started trying to lay out the whole calendar in advance, which I think works out well. We tried to do our due diligence to make sure we weren't butting up with any holidays, which we had an issue with the one year. So I think we've double checked those, and so we just presented these at our typical intervals, which starting with the first meeting in May, unless of course we have a scheduled meeting when the legislature's in session. But we would propose this schedule for 2020 with a May, July, September, and December meeting.
Yeah. So I guess the only follow-up with that is, before we take a vote on that, does anyone interested in opening up a betting pool on when or if we'll actually meet in person over the next year? You've got 4 choices or none at all.
I think it'll be Zoom.
Okay, there you go.
Not before the third quarter.
All right. September 14th is probably going to be a pretty hot pick. Yes, Secretary. Okay.
I was just saying my bet is we'll have one.
Okay, very good. Well, I guess we need to vote on those dates. Is that correct, David, or is that just we can agree to them?
Yeah, I think we could just agree on if there was any strong objections, I certainly would consider. But if everyone seems to be okay with those, I think we'd go forward with that schedule.
I appreciate you putting it all out in advance.
Okay.
All right, moving on. Old business. I don't recall any old business hanging out from last time, but if there is any, please remind me of it. If none, then new business.
I just like to compliment our chair tonight. I thought you did a good job sort of making the members of the public who were here aware of who we are and what we represent and giving us some sense of who they were. I thought it made things warm up and people had a better sense of the commission composition.
Well, thank you. I think the members or the persons who joined and gave comments, I found all of them thoroughly interesting. And even though I didn't have the timer that Delegate Klippinger has with Judge Karoom, it seemed like he was moving along at a good pace. So,
yeah.
Okay. Yes, Brian.
Okay, well, I do want to revisit the issue that we discussed earlier and would make a motion to have staff at least look at the classification for the possession and distribution of child pornography, especially in light of when it was previously classified versus the statutory changes that would reflect where it should be properly classified. My understanding is that would go to the subcommittee and we could have a discussion on that. And if there's nothing there and it's the legislative issue, then obviously we can resolve it there. If it does appear and staff finds that there's appropriate reclassification discussion that should be had, I think we could probably vet that out there and come back with any recommendations. So that would be my motion.
Judge Avery?
I second the motion.
Okay. So I guess the question is there any objection to referring that topic to the subcommittee for further review? Okay, seeing none, there you go, Judge Avery. You have your first topic for the next meeting. Okay. All right. Any announcements? Dr. Saleh, do you know of any announcements we have to make?
I do not know of any. I don't know of any further.
Okay. Is there any further business then to attend to tonight?
Did we acknowledge the death of Senator Sarbanes?
You know, Senator Kelly, we did not do that. And thank you.
I think he was a great public servant and one who represented us very well. And we hope that his family can take comfort in the life that he lived and the contributions that he made.
Thank you, Senator Kelly. I hope everyone will say room and prayers or thoughts for his family and himself, as well as with Mr. Davis that we recognized earlier.
Right.
Okay. Well, with that, I think that concludes our business for the year. I thank everyone for their efforts. It's been a difficult year. Obviously, we would prefer to be in person. But I can tell you, Zoom did not halt the robust discussions. We can at least admit that. So.
Yeah, you're right. Okay.
With that, Dr. Saleh and staff, thank you for another wonderful year that you have all put together and accomplished such a significant amount of work this year through more difficult circumstances than we ever could have anticipated. And we look forward to a very successful 2021 as well.
Thank you.
Thank you.
Yes, everyone stay safe.
Take care, everybody.
Okay, everybody have a happy new year.
Take care, everyone.